Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Lexis Nexis. It's an important book and I think it's valuable from the point of view of both a represented party and an unrepresented party in view of the very large number of people who don't have legal advice and attend relevant hearings to try to sort out a dispute over unfair dismissal. The book is called Unfair Dismissal. It's a paperback. It's a regular publication annually. It's the guide to relevant case law, so it's all the cases nicely brought together. It's now in the 37th edition and it's currently under the editorship of Daniel Way. Now, I've given the title, Elizabeth and I talked about the book and I've written a review generally, but we've had a chat. I've given the title for our review, An Important Paperback of Great Assistance to Unrepresented Parties. Now, I think that that's probably its unique selling point at the moment because we have got a major problem. It's not going away. It was one that was foreseen by many but ignored by others, and it's caused a lot of trouble because it's created a huge number of people who are basically attending court without legal representation and all tribunals, and as a result it's taking up a great deal more time. And if one was doing a time and motions study on legal aid and on the whole areas of trying to give support to people who do need representation, you might come up with some interesting views. Probably not quite what you think because the cost of the legal aid budget was pretty massive. So you can see there are arguments both ways, but I'm very much a man that believes that you should try to give and put resources to those areas that need them, and it's got to be looked at in a fresh way in the future because the days of the old legal aid concepts have gone, but we've got to use our facilities in a different way, and that's what we're doing certainly with the new technology. Now this book, I'm going to show it to you first, was a paperback. There it is. There's nothing on the side or the back really at all. Just opening it up, it's not a big book at all. There's the front page, and you can see the detail. That's the detail from Lexis Nexis. Then you've got the content section. Now I'm not going to go through this in great detail because you've got all of the cases that are mentioned, very large number, a very large bulk of them coming obviously as they do throughout the year, and this is every year. Then the introduction, which I think is most important. Anybody who is unrepresented as a litigant in person should read the introduction if they're going to use this book, because it then covers the main areas where the case law is, starting with statutory exclusions and qualifications and so forth. And then right at the end, on page 152, you get the very last case which is cited. And I do feel, again, each time you've got a case, you've got the name of the case and you've got a little subheading. It's a little bit like, if you have seen it, Current Law from Sweet and Maxwell, but it's the same basic approach, which is to give us as much help as possible. So what do I say about the book? Well, we welcome the excellent short paperback now from Daniel Way as editor of Lexis Nexis in its 37th edition. The guide's aim remains to give employment law practitioners a view on the current approach of the courts and tribunals to various problems of statutory interpretation, because it's a statute-based subject matter, if you like, and obviously therefore we've got to see the thinking of the judiciary and the way they interpret what Parliament has produced. The book contains extracts of the relevant law, analyses of the most important judgments, and extracts of the main relevant findings. And I think it's laid out in a very simple style, which everybody should be able to follow. I do appreciate that a large number of unrepresented parties do not have English as their first language, and that in itself can be a bit of a hurdle. But however, I think the book is relatively easy to look at and read and digest and understand if you take it slowly. Now what Mr. Way has done is he's added 14 new principles from the cases that have been reported during 2018, which I think will be an invaluable asset to court users. And this is a publication that should be readily available to people. It's useful, of course, to recall that very few legislative changes have taken place concerning unfair dismissal in the year, although the statutory extracts included here are generally those in force at the end of 2018. Whether we're going to get any further this year, I don't know, because everything is very much predicated by the decision to leave the European Union, which has meant that domestic legislation has basically disappeared for the time being. But at some stage we will get some decisions, and then we'll be moving forward, as the current expression is. Now, the work, I think, remains a superb, concise, annual updated guide for us. The authors gathered together all the key points from the most important unfair dismissal cases reported in industrial relations law reports, providing a valuable reference tool for all. And as the publishers say, it extracts those principles that are still relevant today from cases reported since 1972. In fact, it mentions it at the front and in the main part at the beginning of the paperback. We recognise, as Way does, that the guide is essential for anybody involved in, or everybody in fact involved in advising, acting or adjudicating in this area, or for anybody who needs to know the current approach of the courts to the range of problems of interpretation posed by the statute. And can I just say here that obviously the people who determine what's going to happen are very experienced, generally speaking, as well, and they will be relying on this work. So it gives you some idea that you'll be on the same wavelength if you've got an unfair dismissal case and you know you're going to be having to mention some case law. This is the sort of publication that they will be relying on. Certainly the new edition adopts the same methodology as in previous editions, and what the author, the editor, aims to do is when he says this, that where the emphasis in the judicial interpretation of the statutory language has shifted, this has been taken into consideration. And I think he puts that in a very nice way, because basically attitudes change, and they're changing quite quickly. You know, a few years ago, it was a very long period of time before there was a noticeable change, and I think the change has speeded up. And he goes on to say it's useful that consideration is also taken together with whether the relevant principle for the reported case would still be regarded as authoritative were it to be scrutinised by the appeal courts today. And that gives you some idea of the fact that there is the change. And of course, Elizabeth and I are naturally reminded of the somewhat often thought of concept that today's dissenting judgment is possibly tomorrow's good law. Now, it doesn't always work, but Way also comments that if there are conflicting lines of authority, both sets of decisions are referred to unless a clear trend has been established in favour of one or the other. Now, I can think in the law of contract, for instance, where you've got a number of very, very clear collisions between one court at the same level and another court, and you end up with a completely neutered idea of what the law really is. And so what Daniel Way is doing here is he's actually trying to give you a balance so that you can put forward a particular submission to the relevant forum, court or tribunal. Let me finally say that the guide takes the law as it stood at the end of 2018, and it includes cases reported in the IRLR up to the end of 2018 itself. And the statutory extracts, as I indicated earlier, included are those in force by the end of 2018. And the 37th edition of the paperback came out on the 14th of March 2019. Let's just have a quick look again at it. There it is. No spine detail there or anything, nothing much on the back, just the standard blurb. And just going in again, you can see the text when it first appeared. It's been around a while, this book, and as I say, it's an important book. There's the blurb from Lexis Nexis, and the content section. Actually, the type is quite small, but you can see the structure. It starts off with statutory exclusions, meaning of dismissal, reasons for dismissal, reasonableness, and remedies on the next page, and then you get into the case list. So you can see, just opening it in the middle, as I said, general test of fairness. That's probably a very important area. You can see how he structured it. You've got the legislation, and you've got the meaning and the relevant cases. So I hope it's of some help to anybody who's going down this particular route. Now, we've had a rather unfortunate history with employment tribunals in recent years, with the costs of fees going up then coming down, and at the moment we're in a position where there are a very large number of new complaints if I can put it that way, but new issues concerning unfair dismissal. So this book, I think, is very timely. Thank you to Daniel and everybody else. I'm very grateful indeed to have this book. It makes our lives so much easier. Thank you. Bye-bye.